The law expressly allows Pam Bondi, says she may make multiple interim appointments by referring to a person appointed rather than the person appointed. See what these lawyers are doing? It's like, oh gosh, a versus the. Yeah, what if your indictments are tainted from the very beginning because your attorney is unlawfully appointed? You know, these judges, man, any little gap you give them, we've seen them exploit to create nationwide injunctions that prevent illegal aliens from being deported and all sorts of other insane things. Trump's DOJ now responding in 2 cases with 1 filing against James B. Comey, former director of the FBI, and Letitia James, who are both being prosecuted by the one person we know as Lindsey Halligan. And she was appointed now as the interim U.S. attorney for this jurisdiction. And the defendants, Comey and Letitia, they're saying she's not properly appointed. She's like Jack Smith. She's not a real boy. And she needs to be disqualified. And Letitia wants the whole case to be dismissed, saying the prosecutor who brought it, who created the grand jury and that led to the indictment, was all tainted for whatever reason, and the case needs to go bye-bye. And so now what we see is Lindsey Halligan, if she is disqualified, that's going to throw a real wrench into the Trump DOJ case against 2 very important people, James Comey and Letitia, who in our opinion are both criminals. Now here's what Lindsey Halligan says in response. All right, we're now responding in 2 cases, the Comey case and the Letitia James case. They say that they want their indictments, the whole case dismissed. They say Lindsey Halligan was improperly appointed. They're saying she's not a real boy. Now, because Comey and Letitia's arguments are basically the same, just like them, this court has consolidated the motions for argument, and we're consolidating our response. And so we're going to respond squarely to Comey, who filed a motion to dismiss. He's saying the same thing, selective and vindictive prosecution. Although we obliterated that yesterday, taking a look at Comey's emails back and forth to the Columbia law professor called Daniel Richman, who's like, this is pretty fun. I'm doing a great job, yeah. And they were colluding to leak materials to the media. Although Letitia and Comey, although they framed their arguments in constitutional terms, everyone agrees that U.S. attorneys are inferior officers whose appointment the Constitution permits Congress to vest by law in a head of a department like the Attorney General. Okay, everybody agrees on this. We're looking at the Constitution, Article 2, Section 2, Clause 2. What are the difference between inferior officers and regular officers? They're going to explain. Now, all further inquiries agree that Congress in the statute, so we're following the bouncing ball from the Constitution to U.S. Code, they did in fact vest this. The Attorney General has the power to appoint U.S. attorneys for at least 120 days. Now, the sole question in this issue is whether this provision of the law, 546, authorized Pam Bondi to appoint Lindsey Halligan here, where a previous interim U.S. attorney vacated office after serving 120 days and being reappointed by the district court. They say the law by Congress gives us the power to do exactly what we're doing, unlike the Jack Smith case, where they cobbled together, if you look at his appointment order, a bunch of different statutory provisions that said that they could create a special counsel. We cobbled those together. They called them the Reno regulations for Janet Reno. Remember her? Under the law, Congress said this, except as provided in another subsection, they write, the Attorney General may appoint a U.S. attorney for the district in which the office of the U.S. attorney is vacant. Okay, very simple. That's the law, 546, subsection A. By its plain terms, that power is subject to one and only one exception, subsection B, which bars appointed individuals to whom the Senate refused advice and consent. So if the Senate says, okay, we've considered that person and no, then you can't appoint that person. Now, all agree that the office of the U.S. attorney for this district was vacant when Halligan was appointed. That's the law. And no one claims that subsection B applies because the Senate has not even acted on Lindsey Halligan's nomination. So they haven't rejected her. Because this law is plainly satisfied, that's it. That's the end of the discussion. Lindsey Halligan's appointment is valid. Now, Comey and Letitia, they say no. If you look at other sections though, like if you look at the B, C, D, E, F, whatever, it impliedly, it doesn't say it explicitly in the law. It's like, well, it kind of says, it's like implied, it's the implication, saying it prevents the Attorney General from appointing an interim U.S. attorney 120 days after her first interim appointment. So you only get like one shot at it. You can't do it again after the fact. But the law says no, it doesn't say that at all. 546C2, another provision that they're trying to latch onto to say Lindsey's disqualified, it permits a person appointed to serve until the expiration of the 120 days. Thus, each appointment under the law may not exceed 120 days. The Attorney General must revisit her choice periodically, consistent with the nature of interim appointments. Instead, Letitia and Comey, they read the section to impose an aggregate 120-day limit as if an appointment appointment expired 120 days after the initial appointment by the AG. So in other words, it's a shorter time period. You'll get 120 days total. Once you have an interim attorney who's gone, you can't then appoint somebody else. So defendants also invoke another section. It says, after an appointment expires under the law, the district court for the district may appoint a U.S. attorney to serve until the vacancy is filled. Now, by its terms, that other provision offers a parallel track to AG appointments from PAM under subsection A, ensuring that the office of the U.S. attorney is promptly filled. So if PAM doesn't have somebody in the seat, the court can go appoint somebody in the seat. But they say, as if it said that only the district court may do that after 120 days, but it doesn't say that. You get more than 120 days. But again, Congress made a different choice, and now they're seeking to rewrite this statute, which is not right. Even were Ms. Halligan's appointment invalid, even if you said, okay, 120 days, or you can do 120 days, and after the 120 days, do it again, another 120, or do it again, versus you get 120 days total. They say, look, even if she is invalid, you still should reject their motion to dismiss. Now, while they challenge her appointment as the interim U.S. attorney, the actions that they challenge, in other words, they're just fighting Lindsey, they're not fighting the indictment. The actions they challenge do not hinge on her validly holding that particular office. Any government attorney can present a case to a grand jury or sign an indictment, and the attorney general plainly possessed and exercised the authority to make Halligan a government attorney, as the U.S. attorney is now confirmed. Moreover, any defect in her role doesn't taint the indictments anyways. She was at least a de facto officer, and any errors harmless anyways, since the attorney general, Pam, indisputably could have appointed her in a different capacity to obtain the indictments. In all events, the government has endorsed the prosecutions. Pam Bondi has personally ratified the indictments to obviate any question as to their validity, and at a minimum, any dismissal should be without prejudice, so we can go get new indictments if you want, now that Pam Bondi has cured any arguable flaw in Halligan's authority to prosecute. And they walk us through some of the background here. They say investigative and prosecutorial decision-making is in the province of the executive branch. It's under the presidency. The attorney general is the head law enforcement officer, and they can appoint people. Congress has also provided for the appointments of U.S. attorneys for 4-year terms, but because the U.S. attorneys are inferior officers and subject to the control of Pam Bondi, who is an officer, ultimately the president, Congress may also vest in law the power to appoint U.S. attorneys to the president alone. So lots of rules and backgrounds. We've got the Vacancies Reform Act. Attorney generals can appoint things, walking us through the statutes that we saw, and Congress has authorized a lot of this. Now, here's the factual background. On January 20th, Trump took office. What a glorious day indeed. Pause to remember. The incumbent U.S. attorney for the Eastern District of Virginia resigned. I'm out of here. The next day, acting AG appointed Eric Siebert as the interim U.S. attorney under the law. Now, Siebert's initial appointment expired 120 days later on May 21st, 2025, and the judges of the Eastern District reappointed him under the law. So we had somebody else before Halligan. Then on September 19th, 2025 this year, Mr. Siebert left, gone. The next day, the president announced his intention to nominate Lindsey Halligan and send her through the Senate to lead the office in the interim. On September 22nd, Pam Bondi said Halligan is going to be the interim. Okay, so we're going to nominate her for a full position, but until then, she's going to be the interim. Senate got her nomination on September 30th, and we're waiting for some action on that, but they can't even open the government. But after Ms. Halligan's appointment as the interim U.S. attorney, then on September 25th, just days later, a grand jury in the Eastern District returned a 2-count indictment charging Comey with making false statements to Congress in violation of the law, obstructing, and lying to Congress. Then on October 9th, the grand jury came back and hit Letitia with bank fraud and making false statements to a financial institution and more. Now, for each indictment, the only government attorney who signed these indictments and the grand jury proceedings was presenting basically was Lindsey Halligan, and she's valid. They say this is totally in compliance with the law. U.S. Code says, except as provided in subsection B, you can have an interim attorney. It prohibits someone who has been refused by the Senate, but Lindsey has not been refused by the Senate. Hasn't even happened yet. So the criteria are met here. The office of the U.S. attorney and the Eastern District became vacant on September 19th. We saw him leave. The Senate has not refused to advise and consent. Her nominations are still working their way through. So the AG therefore lawfully appointed Halligan as the interim attorney, and all of this stuff should be denied. The cases are that simple. But Comey and Letitia, they say that if we read other provisions, 546C and D together, it really limits the total tenure of the AG's interim appointment to 120 days. So in other words, she's out of time. She loses the opportunity to appoint anybody else in the interim because Eric Siebert was already there for a long time. time. So he's gone. So she gets 120 days. Your clock expires. Now you can only be appointed by the court, is their argument. After which only court-appointed interim U.S. attorneys are allowed, saying that this is the rule. Now they rely on these subsections, which states that a person appointed as U.S. attorney under this section may serve until the qualification or the expiration of the 120 days. They say, what are you talking? She complies with this fully. Senate has not confirmed her, and she has not been in there for 120 days. Nothing in the text explicitly or implicitly precludes Pam from making additional appointments after the 120 days. So she can go back. Oh, your term's expired. Guess what? You're reappointed, Lindsey. And again, and again, and again. Again, subsection A identifies only one exception to that authority. It's subsection B. It's not subsection C. So you can't reference that other statute and say, well, this limits that. No, because it says the only thing that limits it is B. So refer to that. Refer to that. It says if the Senate rejects her. Senate has not rejected her. End of the story. Now, if anything, what this says is that the law expressly allows Pam Bondi, says she may make multiple interim appointments by referring to a person appointed rather than the person appointed. See what these lawyers are doing? It's like, oh gosh, a versus the. Let's spend about 50 pages talking about the difference. Defendants recognize as much, but they say that Pam must cram multiple appointments into a single 120-day period, otherwise clock expires. But the far more natural reading is that each appointment triggers its own 120-day clock. Each person appointed may serve until 120 days after the appointment. It doesn't mean it's 120 days total. They don't automatically renew either. The process provides political accountability, so Pam has to go and do it again, ensuring that the appointee without Senate confirmation cannot serve indefinitely without frequent personal review by the AG, who is duly appointed and Senate confirmed. At the same time, Congress did not hamstring the Attorney General with an artificial one-time only appointment window, like use it or lose it. Now the court gets to appoint everybody indefinitely. Now that reading also tracks the ordinary presumption that you would expect. When a statute provides for an appointee to serve a term of 4 years, the specified time of service begins with the appointments. For example, if a Senate-confirmed U.S. attorney resigns before the end of the 4-year term, a new Senate-confirmed attorney is entitled to his own 4-year term. It triggers a new term. Same thing is happening here exactly. You have a new interim appointment, you get a new 120-day clock under the rules, and you avoid any artificial limitations. And by the way, the Fourth Circuit precedent also supports this conclusion. Okay, the Court of Appeals said this in 2024, judges. The circuit addressed a regulation authorizing the appointment of a temporary Board of Immigration Appeals members not to exceed a term of 6 months. An alien sued, said you can't keep reappointing the same person to 4 successive 6-month terms. You get to play 4 times and you just keep getting reappointed and reappointed. The court rejected the challenge from the illegal, recognizing that the regulation's language doesn't restrict the power to appoint the same person to multiple consecutive terms, so successive terms are permissible. As the Eighth Circuit, another court says, in rejecting a similar argument, implying a limitation on successive appointments would be inconsistent if you limit Pam Bondi the broad power to make appointments and delegate duties to their subordinates. And nothing in the law limits Pam and her ability from doing any of this. Now, contrary, the defendants argue, they say no, it has to be 120 days only. They say this is ridiculous. That reading violates the basic rule that courts may not add words into statutes and just shove words in there. This clock that's in the law is from appointment. It says appointment. It doesn't say initial appointment. You shove that in there, but it's not in the law. Their justification for this are also untenable. They make a bunch of arguments, and again, we're talking about the language. They write, Congress, they say from Comey and Letitia, that if Congress wanted each appointment to last up to 120 days, they would have made appointments expire after that appointment or after his or her appointment, rather than 120 days after appointment, right? So appointment, they're saying that means the very first in time appointment that has ever happened. And if they wanted it to be more specific, they would say his appointment or her appointment or that appointment. Second, Comey says that the government's reading renders superfluous under this statute, but under this statute serves other functions. So if you read it our way, it doesn't invalidate this section of the law. That section still has power. Comey says if you follow what Halligan says, then all of this language is meaningless. They say, no, it's not. It's right here. It's perfectly meaningless. Here's what this does. Here's what this does. It's there for a reason. The logic of the statute is perfectly applicable under our interpretation. Third, Comey asserts that the time limit in the law under C1, that an interim U.S. attorney may not serve once the Senate confirms the nominee, is not appointment specific, but they say it is perfectly clear. It says appointment to refer to the person who is appointed. Seems pretty obvious. But regardless, this does not address a specific appointee because it sets out a condition that does not turn on the status of any interim appointment. Once the Senate confirms a U.S. attorney, the interim office holder is out, regardless of how long he or she served or who appointed her, because you're interim. Then you're replaced by your duly appointed individual, even if it is you. Subsequently, by contrast, this is when the appointment happens. And so their reading also contradicts the statutory history. If you listen to Comey and Letitia's perverted interpretation of the law, it contradicts all of the statutory history that came before the law. Now, as defendants recognize, between 1986 and 2006, this section was identical to the current version for that long period of time. During that period, the government repeatedly used successive 120-day appointments for interim U.S. attorneys. We've done this a lot. 120 comes and goes, and you can just stay on. So Lindsey, 120, 120, 120. Now, if the Senate hears her and rejects her, then she can't get another 120. So you got to think about that too. For the U.S. attorney, in 1987, the AG reappointed an interim U.S. attorney, same person after the 120-day clock had run. That appointment was challenged in court, and it was upheld. That person was allowed to serve a second time. The CRS, the Congressional Research Service, they also report that between January 1993 and March 2006, at least 8 U.S. attorney vacancies, 3 under Clinton, 5 under Bush, were filled with successive appointments. 120, 120, 120. Now, in debating later amendments, Senator Kyle, probably John Kyle from Arizona, identified 2 pre-2006 instances when interim U.S. attorneys served 3 or even 4 successive 120-day terms. As far as the government is aware, the only district court to consider the practice contemporaneously approved it. In this other case, and until the current administration, until Trump came in, guess what? No court even questioned it. But now everything changes because the government is now arming itself against the American people, the courts especially. In 2006 then, so prior precedent showed that other presidents had used this repeatedly for a long time. Bush, Clinton, all of them. Then in 2006, Congress amended the law. They eliminated the district court's appointment power, and they permitted the AG's appointee to serve indefinitely. But following controversy over the Bush administration and their firing back in 2007, Congress then reverted back. So they were going to make it more permissive. They were going to, in other words, let Lindsey Halligan serve as long as she wants. Then Bush screwed it up, and they reverted. Language that was still well understood to authorize successive appointments, turned it back. They write, where Congress has chosen to maintain the relevant provisions and here affirmatively reenacted them, they had it one way, changed it, and changed it back. They say this was ratifying the practice. And citing legislative history, Comey and James, they go back and they say, no. The reason why they made those amendments was to stop these interim appointments. But legislative history is not law, and you can go find reasons why some senators spoke out about it. We have to bring this back and do this. Okay, that's fine, but that's not what the law says. And the legislative history is like looking over a crowd and picking out your friends. Oh yeah, that senator said this. So the purpose of passing the new amendment was to do whatever. Well, did that make it into the law? Like, did they write that into the law that this is what we're doing? They didn't? Oh, great. Then it's just back to the way it was. And you didn't stop it, so it's like you're ratifying it. While some members certainly wanted to prohibit this, Senator Kyle correctly pointed out that because the bill reinstates the exact language that existed before the amendment, the AG could make successive appointments. They just kept it the same. They wanted to prevent successive appointments. Why didn't they put that back in there in the amendment? Congress was even aware of this and said that the Attorney General could rely on pre-existing legal rationales to specifically make successive interim appointments. And the Senate rejected, in fact, an amendment that would have repealed this authority altogether. That was rejected. If Congress wanted to block these appointments, then they could have done it. Returning to the former text and just saying everything is exactly like it used to be is a bizarre way of eliminating that limitation. Instead, the 2007 amendment means what it says. It says the AG can no longer make a single indefinite appointment as she could under 2006. She has to go revisit it every 120 days. And courts may once again appoint interim U.S. attorneys as a backstop. Courts have the power if they can't get the slot filled. But in reenacting this pre-2006 text, Congress presumptively ratified this long-standing practice that Bush and Clinton all used. Successive 120-day appointments under that law is permissible. Now, Comey and Letitia, they also go back to this 1986 memo by the Supreme Court judge, who was not the Supreme Court judge at the time, Samuel Alito. He was a deputy assistant attorney general, and he wrote this memo identifying a purported congressional purpose that after the expiration of 120 days, interim appointments are to be made by the court, right? So Alito in this memo is saying, well, you do get 120 days total, is what Comey and Letitia, and they're writing for one audience up there, Judge Alito, saying, hey, remember that memo you wrote, Judge, back in 1986 where you said it's 120 days max, then it goes to the courts? That's why we're here. But the deal DOJ says, consistent with the era in which it was written, the extent of the memo and their analysis is a citation of a single House floor statement, and it's not the law. Now here they write, Alito wrote this, declining to follow the approach of a 1986 case that jumped right to the legislative history rather than starting with a text of the law. And the cited statement does not even suggest that the AG cannot make multiple appointments that total over 120 days. The congressman that Alito was referencing merely said that once an interim appointment expires, the judge can then appoint a U.S. attorney, okay? Not that they're not getting reappointed. Like if it's empty and there's no one coming in there, yeah, the courts can fill it. The government cannot let 120-day appointment lapse, but multiple shorter appointments may be allowed. Now, in any event, they say the memo from Alito left open whether the AG could make an additional appointment if the district court failed to act, and so that refutes Comey's claims entirely, saying it's the same approach. It's not. Subsequent DOJ practice also after Alito rebuts any suggestion that the AG is limited to a single 120-day period, and many successive interim appointments can be made in the aftermath. Continuing, Halligan responds to Comey and Letitia. They also say, such a dumb argument from these two. They say that there are other implied limitations. Here, Eric Siebert, the first interim, his initial appointment expired on May 21, and the judges of the Eastern District appointed him to a new term, subject to presidential removal. But he then vacated his office on the 19th, and nothing in the subsection limited Pam's ability to put somebody else in there. It's exactly what she did. And the law refutes Comey and Letitia. Subsection D says that the district court for such district may appoint a U.S. attorney once a 120-day appointment has expired, not that only the district court may appoint. It says that they can, but not only they can. So that means that Pam can do the same. And we have parallel tracks on this all the time. It's either the AG or it's the courts. It's the AG and the courts. If the AG doesn't act, the courts will backfill it so justice can carry on. Parallel tracks are especially common in this context when talking about appointments to ensure the continuity of government. For example, this other provision allows the AG to designate certain subordinates to serve as acting AG during future vacancies. We've also got Fourth Circuit in this case law and more. They also accept that Pam may make at least 120 days worth of appointments in other contexts, and they understand, they even recognize in their own motions the importance of these mechanisms. But they're also not correct that concurrent authorities would create conflict. They're saying, well, what happens if Pam wants to shove someone in there and the courts want to too? This is going to be a conflict that's going to wreck everything. Now, to the extent whether there is a dispute over whether a district court or the president should decide who gets to wield this power, the Constitution is clear. It's the president. The president makes those appointments, and that's going to override the judges trying to usurp him. In any event, there is no conflict. In this case, the district court did not appoint anyone in the days after Siebert left, and Lindsey Halligan came in and took the spot. So there is no conflict at all. Now, at bottom, Comey and Letitia's arguments, they sound in policy, okay? Not the text of the law. They're not looking at the statute. They're just saying, well, we kind of would prefer the policy, and we think the policy is better this way. Okay, well, you're not Congress. Congress sets the policy, and they've got the wherewithal, arguably, supposed to make those determinations, weigh out the policy considerations, and come to a final conclusion and write it down in the law. If the AG could string together 120-day appointments, they say, the executive branch could circumvent the district court's role in all of this. But even the most formal policy arguments and formidable policy arguments, they say, cannot overcome the law, a clear statutory directive. Just because you don't like it doesn't mean you can override the law. Lots of judges are doing that these days, however. And Comey and Letitia's concerns, they ring hollow, given that the government previously let the district court make an appointment and has now submitted Halligan. We're going through the literal process. There's no conflict at all. And we secured Senate confirmation of 16 U.S. attorneys mere weeks ago in those blanket hearings. Now, defendants and their policy, so Letitia and Comey, they also assume that the conclusion of the law seeks to make the court, not the AG, the sole appointer of U.S. attorneys, which is obviously ridiculous. It's not that. It's a failsafe. Their own reading and interpretation also doesn't guarantee that the courts make the appointments. And even the Alito memo says that successive appointments might be appropriate if the district court fails to act. So both sides are covering for each other. They're both working on filling the spot. Now, Comey and Letitia, their concerns over bypassing Senate confirmation are also particularly puzzling here. They're saying, well, if you can just keep appointing 120 and 120 and 120, you don't even have to send them over to Senate confirmation, and then you can have somebody who's kind of, not a confirmed attorney prosecuting all these cases. You see, but this is puzzling. Even on their reading, court-appointed interim attorneys can serve indefinitely. So if you follow their rules, that's still bypassing the Senate. If the court appoints somebody, how's that different than the executive appointing somebody? somebody. Historically, district courts have overwhelmingly reappointed the Attorney General's choice until the Trump era, as has happened with Mr. Siebert and multiple U.S. attorneys in the Fourth Circuit this year. Now, in practice, Comey and Letitia would frequently allow the president's pick to serve an entire 4-year term or longer without even a periodic assessment. So there is a reason, however, that lengthy interim appointments are the exception, not the rule. In addition to obviating the need to revisit an appointment every 120 days, the imprimatur of Senate confirmation offers tangible benefits, telling courts and litigants that the two branches of government are backing this attorney. The executive have little incentive to forego those benefits across the board, which is why the presidential appointment and Senate confirmation remain the norm, even though this allows us to fill the vacancies. Like, we want somebody who's got the stamp of the Senate in addition to the executive. And again, the claim that the government engaged in a gambit makes little sense. We're following the rules exactly. We made appointments. Halligan is making her way over to the Senate. So there's not this attempt to run around the Senate. Now, to the extent that the law is ambiguous, if you go, well, we don't really know what it says, constitutional avoidance, which is this principle that you don't go looking, the courts shouldn't be looking for conflicts because we're all part of the same government, but currently they have. It favors our reading. There are few functions more quintessentially executive than prosecuting crimes. It's what they do. Article 2, therefore, requires that the president have complete control over the investigation and the prosecution of the law. So Article 1, legislature; Article 2, executive; Article 3, courts. Article 3 requires courts to carefully abstain from intruding on the executive branch. Now, Congress may permit courts of law to appoint some inferior officers, but Congress may not do so in a way that is incongruous with appointers' judicial duties or which interferes with the executive. We've got separation of powers that need to be respected. Now, their position from Comey and Letitia would take us into a constitutional disaster. It would allow Article 3 courts to control the appointment of an executive official even over the president's objection, if they got their way. On their view, once the 120-day clock has run out, only the courts can appoint a new attorney until somebody is Senate confirmed. The president, of course, remains free to remove whomever the court selects, but that arrangement raises the possibility that the courts repeatedly could continue making appointments unacceptable to the president, and the president could continue removing those people until the court picks someone that he likes. Now, that regime is profoundly destabilizing than the one where the attorney general and the district court make simultaneous picks and the attorney general's pick prevails. Lots more, we're working together. Courts should strive to avoid, not embrace, these interbranch conflicts. This raises serious separation of powers issues. Now, this case illustrates the dangers right here. Presumably because the previous interim U.S. attorney was appointed by the Eastern District, those judges on their own, sua sponte, transferred the present motions to this court. Other courts have felt compelled to transfer similar cases, and courts should avoid an interpretation that would routinely put themselves in an uncomfortable position. You're not supposed to be in the middle of the conflict. Instead, consistent with the Constitution and the Appointments Clause and the separation of powers, Congress gave the courts only a narrow but important role of making the seat filled when political branches ultimately fail to act, and they haven't done that now. Lindsey Halligan is in the seat, but as a backstop, even if you find that Lindsey Halligan and her appointment is invalid, you should not dismiss these cases. That doesn't make any sense at all. Even if it was invalid, which we're saying it's not, dismissal with prejudice so we can't recharge these people would not be an appropriate remedy for what is the most procedural, at most, a procedural misstep in how the phrasing of the appointment occurred. James's request for relief should also be denied because Halligan has been reappointed, just to be clear. Now, her motion, Letitia's, and Comey's motions, they evince a fundamental mismatch between their asserted violation and their request for a dismissal. What was the harm that came upon them? What is the remedy that they deserve? While they assail Lindsey Halligan's purportedly unlawful title, their indictments in no way depend on that title. No federal rule exists which demands that a U.S. attorney, somebody Senate confirmed and lawfully appointed, sign every indictment. You can just be an attorney working for the government. Instead, an indictment only needs to be signed by an attorney for the government. That's it. Federal Rules of Criminal Procedure 7C1. Likewise, attorneys for the government may conduct grand jury proceedings. So even if Lindsey, she's not interim, she's not acting, she's like the lowest attorney government worker, great, still can do it according to the rules. Likewise, attorneys for the government may conduct grand jury proceedings. In many districts, assistant U.S. attorneys routinely sign indictments, and any vacancy or defect does not affect their power. That's because their ability to do this does not hinge on the authority of a local U.S. attorney, but it's coming from the AG, which has plenary power, broad power over litigation where the U.S. government is a party. So likewise, any flaw in this appointment as the interim attorney does not affect her ability to exercise Pam Bondi's power. Whatever her title, Halligan is still an attorney for the government, authorized to conduct grand jury proceedings and sign indictments, just as she is an attorney for the government bound by the grand jury secrecy rules. She's protected by the government's attorney-client privilege rules. She's entitled to a federal paycheck, after the shutdown's over. The federal rules define an attorney for the government is not specifically a U.S. attorney or assistant U.S. attorney, but it's any authorized assistant to Pam or any other authorized by law to conduct proceedings as a prosecutor. Now, the Attorney General Pam has broad powers. She may appoint people. She's done that individually and collectively. These authorities amply authorize Halligan to conduct the prosecutions authorized by Pam Bondi. And if you have any questions about it, let's be sure. Miss Halligan's original appointment cited only Section 546, consistent with the government's view that she's not limited to 120 days. But an agency doesn't need to cite specific statutory provisions on which it relies when making a decision. Look at this case from the Supreme Court. And courts ordinarily interpret legal text to avoid rendering them invalid. And Scalia wrote that. May he rest in peace. There is no question that Pam Bondi intended to vest Halligan with the powers of a U.S. attorney and thus authorize the litigation. She recently confirmed this as well. Now, Halligan's original appointment should not be read to nullify because it came from Pam. Even if Halligan lacked the authority, the indictments are still valid for three other reasons. Let's say you take Lindsey out. First, the Fourth Circuit Court of Appeals has long said that the signature of the prosecuting attorney is no part of the indictment and is necessary only as evidence of the authenticity of the document. That means if you have somebody improperly signing an indictment, it doesn't invalidate the indictment, Fourth Circuit. It's a mere technical deficiency. It's not automatically fatal to the indictment anyways, citing a bunch of cases. Multiple courts, therefore, have held that an indictment is not valid if the prosecutor was not licensed to practice law, if other evidence was not invalid, let me say this, if they're not licensed to practice law, if other evidence indicates the government endorsed the prosecution. Man, that's crazy. So don't even have to be a lawyer. From Massachusetts, 2019. For example, the only government attorney to present evidence to the grand jury and sign the indictment, in this case, this person was suspended from practicing law. A court still said, well, the indictment is valid because other government lawyers agreed with the grand jury that the indictment should issue and they signed it on later filings. Gosh, that's crazy. So a prosecutor who's suspended can still indict you in Massachusetts. Incredible. Those cases confirm the validity of these indictments, and Lindsey is not suspended. There is no question as to the indictment's authenticity or the grand jury return of it. Other federal prosecutors with unchallenged appointments have signed subsequent filings, and the AG has personally ratified everything. So that readily distinguishes this case from other cases where there was no official approval of anything. So it's valid even without her. It's been ratified by the rest of people who are. Second, even were a government's attorney signature necessary, and even were Halligan not a government attorney, her actions would still have de facto validity. They say the de facto officer doctrine confers validity if they're acting under the color of law, when it's later discovered that they are deficient. This doctrine springs from the fear of chaos that would result if every action was challenged. Even if the Attorney General failed to properly appoint her as an officer de jure, she was acting under the color of law, and so her past actions are valid and binding. But Comey and Letitia say no. They try to bootstrap their claimed violation. They say if this is a violation of the Appointments Clause, just like Jack Smith, citing the Supreme Court case declining to apply this to certain Appointments Clause claims. They say this case distinguishes their arguments, but on their theory, every statutory violation would become a constitutional violation since the appointment in violation of a statute would not be authorized by law. And so this concept doesn't apply, and other cases are even further out there from them. They invoke another passage in Collins versus Yellen, a 2021 case. But the cited passage that they reference merely described how the challengers characterize certain cases in distinguishing those cases and rejecting their argument. So it's actually helping us, not them. Why are they citing that when it supports our claim? There, the court found that the appointment was unconstitutional and irremedial because there was no statutorily created office to fill in the first place. Like the entire office was invalid. This office is not invalid. Your case doesn't even matter to what we're arguing here. Even on its own terms, that reasoning has no application here. The office of the U.S. Attorney plainly exists. The question is only whether Halligan is properly filling it, not whether it's real or not. So why are you citing that case? Third, any error in their indictments are also harmless. The grand jury, had proper independence and decided to act, and they're a check on the whole process. Failures by the executive branch, even prosecutorial misconduct, provide a court no authority to dismiss this. You have to have a finding that the defendant was prejudiced by the misconduct, and that rule applies here too. You can't dismiss it unless you can show some some real problems. In this context, prejudice that they would have to show would mean the government and their misdeeds substantially influenced the grand jury's decision. And there's grave doubt that they were free to make a fair decision at the grand jury stage without that improper influence. They can't show that at all. Given Pam Bondi's expansive power to appoint these people, there's no question that she's made explicit that AG Bondi could have authorized Halligan to do all these things. Even if she's not even an interim attorney, she could have done those. The AG could have also hired Halligan as an assistant attorney, making her an indisputable attorney for the government. Now, their basic claim, therefore, is at most, if you look at it and find in their favor, it's at most a paperwork error, that the AG should have cited a different provision in appointing her, and that would have then satisfied everything. But absent her view that she would have been excluded, she would have simply had a different title. That's it. The kind of technical difference cannot establish any grave doubt that's required under the statute. And so they don't want you to even think about harmless error altogether. They say you can find this other exception when it's a structural problem that renders the grand jury proceedings fundamentally unfair. But that exception is exceedingly narrow, and it's exemplified by major structural errors, like where black people had been systematically excluded from the grand jury, or the intentional exclusion of all women from a grand jury. That precedent reflects the special problem of racial discrimination, a problem so pernicious that you don't have to show prejudice. But all of this is far outside anything that's applicable here. Any defect in her job title is not even remotely comparable to the wholesale exclusion of minorities from grand jury proceedings. Now, in any event, Halligan's team says the Attorney General, in whom Congress has empowered to run the DOJ, she has personally ratified all of these indictments. When an officer allegedly appointed in violation of the Appointments Clause takes a challenged action, subsequent ratification by an official with the power to do so cures any defects that may have existed. Fourth Circuit said that in 2025 in October, not long ago. Here, Pam Bondi plainly could have authorized any DOJ officer to go do this and indict these people on her personal authority. And so this ratification from Pam now cures any flaws in the indictments. Now, Comey may respond that a ratifying principal must have been able to take that action at the time the ratification was made. But when a timely filed indictment is dismissed for any reason, we might be able to refile it if it's dismissed without prejudice. Because the Attorney General could go get a new indictment, she may ratify this. So it goes back to her power, not Halligan's. Comey raises some other disputes about refiling indictments, but he does not dispute that a validly appointed federal prosecutor, could be a U.S. attorney, could be assistant U.S. attorney, could be a special attorney, could be Pam Bondi herself. They could have lawfully obtained this indictment. And so the tolling rule would govern any dismissal. Now, at minimum, if you are going to dismiss this case, you need to do it without prejudice, which means the government can come back and refile it. Just go get a new grand jury. Now, the problem with the Comey case in particular is a statute of limitations problem, but they would make the argument that this relates back to this case. We would see how that, if I were defending Comey, would obviously object on that. A new indictment, statute of limitations is expired, you can't do it, but we'll see what the courts say. But James does not request dismissal with prejudice and thus forfeits any request. The maximum relief to which James could be entitled is without prejudice, a remedy that would allow Halligan or any other attorney to now indict them again. Comey does want a harsh remedy. He wants a dismissal with prejudice, but he says that sanction is reserved for flagrant misbehavior, substantial prejudice, where no lesser sanction will do. And he can't prove that here. He's going back, he's rehashing his vindictive and selective prosecution claims that are of a different motion in front of a different judge over which this court lacks jurisdiction. But if the judge, Nachmanoff in the original case, and remember the judge sent off the disqualification case to another judge, if Judge Nachmanoff accepts those allegations and grants the motion, this court would have no need to adjudicate this motion. In other words, if the case is dismissed for selective and vindictive prosecution, the case is dismissed. It doesn't need to be adjudicated to be dismissed on the basis of unlawful appointment, which is a different issue. So the court should therefore proceed on the assumption that his selective and vindictive claims also fail or defer this until that is ruled on. So you can't, commingle the claims. This is separated out for you to make a decision on disqualification. Now, zeroing in on an actual claim here that the Pam Bondi Attorney General could not lawfully invoke this to appoint Halligan, Comey comes nowhere close to showing flagrant misbehavior, substantial prejudice, the availability of a lesser sanction at all. He suffered no prejudice, much less any prejudice based on Lindsey Halligan's title when she was standing in the grand jury room. And contrary to his assertion, the counterfactual where Pam Bondi did not, in his words, unlawfully appoint Halligan is not a world where the government would have let the limitations period run. Instead, Bondi would have cited a different authority that would have authorized Halligan to get the same exact indictment at the same exact time. If the court deems the indictment invalid, any dismissal should be without prejudice to permit the government to swiftly seek re-indictment under 18 U.S. Code. So you can get very conspiratorial here. I pause there for a moment. moment is like thinking about that. Yeah, what if your indictments are tainted from the very beginning because your attorney is unlawfully appointed? Okay, so all of this is just now going to make sure that they cannot get indicted because the judge could dismiss them with prejudice, and then everybody just goes, oh, Pam Bondi just blew the whole thing. Oops, accidentally appointed Lindsey in a wrong way, and the courts come out and dismiss everything with prejudice, and you can't refile it. It's a legal cover-up, right? If something like that were to happen intentionally. Or maybe Pam just, screwed up the appointments or something. But if that happens, it's going to be real problems. James, not Comey, also requests an injunction to stop Halligan from prosecuting anyone else. To the extent that she requests an injunction, it's also improper. Equitable remedies like injunctions must be party specific. She has no standing to seek an injunction against Lindsey Halligan. James's request is also improper to the extent she seeks an injunction. She may seek to disqualify Halligan, but her request has been overtaken by events. She can't be injuncted on anything. Pam Bondi has ratified Halligan's appointment as a special attorney, and because Halligan now has indisputable authority to proceed, any prospective relief in that regard would also be inappropriate. So that is the response from Henry C. Whitaker to the attempts by James Comey and Letitia James to disqualify Lindsey Halligan, and a lot of similarity to the Jack Smith disqualification attempts where we said he's not a real boy, although the appointment powers and the statutes that we're talking about are very different. This is talking about being appointed as an interim attorney, where Jack Smith was allegedly appointed illegitimately, according to canon, as a special counsel, and they cobbled together a bunch of other authorities to create him, called the Reno regulations, which we've gone through here many times to show what a joke they are. They're like FBI statutes and other DOJ statutes and like a Bureau of Prison statutes, and they cobble all those together to say, you're a special counsel now. You're not an acting attorney, a government attorney, you're a special counsel, and under those powers, you can go do these things. And that was all illegitimate, obviously. So it's similar in form, but very different in statute. And so nice response over here. It makes me nervous on this because the judges, as we know, I think this one is going over to a different judge, but Nachmanoff and others are blue judges who may dismiss these cases, just based on some justification that they pull out of their booties. But ultimately, a motion to dismiss is a big decision, and we'll see what the courts do on this, but we're happy to see a very strong response from Halligan and the team, just showing very clearly, statute says we can do this. Prior precedent confirms that. Was this way for a very long time. Congress tried to make it more expansive and reverted back to the exact way it was that allows these appointments to continue. These judges, man, any little gap you give them, we've seen them exploit to create nationwide injunctions that prevent illegal aliens from being deported and all sorts of other insane things. You have to pay the thieves billions of dollars because of democracy or whatever, right? They just make it up. So we'll keep our eye on this one, but Lindsey Halligan and the team now responding to Comey and Letitia, and we want Halligan to stick around because thus far, she's been the only one with any testicular fortitude to actually charge anybody anywhere, and we'll continue to encourage her office to continue.